legal dictation at the speed of 100 WPM. Be ready, 3 seconds left. Start. Having heard the learned counsel for the petitioner and looking to the facts and circumstances of the case, it appears that this petitioner has deposited rupees 30 lakhs wide demand draft bearing number 01 dated 11th October 2019, rupees 10 lakhs wide demand draft bearing number 02 dated 16th October 2019 and rupees 10 lakhs wide demand draft bearing number 03 dated 21st October 2019 with the respondent number 3. In all, the petitioner has deposited rupees 50 lakhs with the respondent number 3. It appears that the investigation is going on for the alleged violation of the provision of Customs Act 1962, wherein the investigation agency has already recorded the statements of the petitioner and the relevant persons under section 108 of the Customs Act 1962. Learned counsel for the petitioner submitted that there are retraction statements made by the persons whose statements have been recorded under section 108 of the Customs Act 1962. B. That as it may the amount which is deposited by the petitioner cannot be ordered to be refunded by this court at this stage, because we do not accept the argument canvassed by counsel for the petitioner that amount of rupees 50 lakhs with respondent number 3 was deposited under coercion, because allegation of coercion cannot be established by way of annexures in the writ petition. In fact, cogent and convincing evidences are required to be led to establish coercion. As the investigation for the alleged breach of provisions of the Customs Act 1962 is already going on, we do not wish to observe anything in favor or against this petitioner for the statement recorded under section 108 of the Customs Act 1962, which are otherwise admissible in evidence. Retraction of a statement is one thing which does not inevitably and in every case necessarily affect the evidentiary value of the statement recorded under section 108 of the Customs Act 1962. At this stage, we are neither appreciating the statement recorded under section 108 of the Customs Act 1962, nor we are appreciating the retraction of the petitioner's statement recorded under section 108 of the Customs Act 1962. At this stage, it will be absolutely premature to come to a conclusion that the amount deposited by the petitioner was not required to be deposited by the petitioner before the respondent number 3. The illegality or otherwise of the deposition of the aforesaid amount depends upon variety of factors like issuance of the notices by the respondents for the breach of provisions of the Customs Act 1962, the voluntary nature of deposition by the petitioner. Sometimes retracted statement may not be accepted by the respondent, etc., or there may be permutation and combinations of the aforesaid facts also. The petitioner can always file a suit for recovery of the aforesaid amount from the respondent number 3. In view of the above reasons, we see no reasons to pass any order in favor of the petitioner for refund of the amount as prayed for in this writ petition. So far as prayer of the writ petition is concerned, there is only a presumption that the respondent is going to take coercive action against this petitioner. We expect from the respondent that they shall act in accordance with law, rules, regulation, and government policy applicable to the facts of the case while investigating the case of the petitioner. With these observations, this writ petition is hereby dismissed.